What if the grandchild moves to another state? What happens when a grandchild moves to another state? This situation can complicate the legal rights of grandparents regarding visitation and custody. Let's break it down. When a grandchild relocates, the court that issued any visitation or custody orders usually keeps its authority. However, if the child and at least one parent have permanently moved, the grandparents may need to go to court in the new state. This is essential for establishing visitation rights or enforcing any existing orders. Each state has different laws regarding grandparent visitation and custody. Some states allow grandparents to request visitation if the parents are divorced, separated, deceased, or if parental rights have been terminated. In many cases, grandparents must show that denying visitation could harm the child or that visitation serves the child's best interests. This means the new state's laws will dictate how grandparents can proceed. If grandparents already have visitation rights from the original state, they might enforce these under the Uniform Child Custody Jurisdiction and Enforcement Act. This act helps ensure that custody and visitation orders from one state are recognized in another. However, grandparents usually need to navigate the courts in the new state to make this happen. Maintaining contact can be challenging due to the distance. Courts often prioritize the child's best interests, which include stability and continuity in relationships. Grandparents may need to prove that they have a meaningful relationship with the grandchild to secure or maintain visitation rights in the new state. The impact of parental rights and the divorce or separation of the parents also plays a role. If the parents are divorced or separated, grandparents may have stronger grounds to seek visitation. This is especially true if the move disrupts the grandparent-grandchild relationship. Courts typically assume that fit parents act in the child's best interest, so grandparents must provide evidence to support their case. For grandparents facing this situation, there are practical steps to consider. First, consulting an attorney who understands family law in the new state is wise. This will help clarify local visitation and custody rights. Next, attempting to negotiate visitation agreements with the parents can be beneficial before going to court. If court action is necessary, grandparents should file a petition in the new state, showing how visitation is in the child's best interest and demonstrating their existing relationship with the grandchild. If physical visitation is not possible, grandparents might consider alternative methods like virtual visits to maintain the connection. In summary, when a grandchild moves to another state, grandparents may encounter legal and practical challenges in keeping visitation rights. The outcome largely depends on the new state's laws, existing legal orders, the parent's relationship status, and the grandparent's ability to show that continued contact benefits the child.